Wondering how to get your employees to waive their meal periods? Join me. Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Happy end of May. Oh my gosh. Wow. Okay, June is coming. This is good. Summer is coming. Ella will be out of school soon. I can't wait. I think she's really tired. She has had a fabulous freshman year of high school, but she's tired. I'm tired. We need summer break. So, hope you're all doing well. We got a really cool court decision about a month ago, and I want to talk to you about it because it's really helpful. Every once in a while, we get decisions that are really great. This one came down on April 21st. It's called Bradsberry versus Vicker Operating Inc. Bradsbery. Bradsberry versus Vicker Operating Inc. The beauty of this decision, you guys, is it provides employers with a really good game plan for having non-exempt employees sign meal period waivers as long as certain criteria are met. Okay, it's a really good decision, and it gives us a really nice sort of map of what we need to be doing. So first of all, in the case, these two former employees worked for a whole bunch of veterinary hospitals. It was a network of them, all right? And they filed a class action lawsuit saying that the company did not handle their meal periods properly. What they were saying is that the company required them and the people they were seeking to represent to work 5 to 6 hour shifts without providing a duty-free 30-minute meal period. And therefore, they should have received those meal period premiums. Okay, you know, under California law, most wage orders, if you work more than 5 hours, you're entitled to an unpaid duty-free meal period of at least 30 minutes, okay? But if you don't work more than 6 hours, you can waive the meal period, all right? And remember that the meal period premiums are 1 hour at the employee's regular rate of pay. The employer, in response to this lawsuit, said, hey, wait a minute. You waived your right to a meal period. You all signed these meal period waivers where you were prospectively waiving all of your meal periods. And the language of their waiver said, I hereby voluntarily waive my right to a meal period when my shift is 6 hours or less. I understand that I am entitled to take an unpaid 30-minute meal break within my first 5 hours of work. However, I am voluntarily waiving that meal break. I understand, and this is critical, that I can revoke this waiver at any time by giving it to my manager. So by giving a written revocation to my manager, all right? So the company says, hello, we got waivers from everybody. And by the way, many of you on this podcast, I've written those waivers for you, right? We have given you those waivers. The employees argue, wait a minute, those waivers are not enforceable because we only signed them one time. And the employer is trying to argue that these apply to our whole employment. We think you should have to sign these on a per shift basis. And only if you're scheduled to work a shift that would be more than 5 hours or fewer than 6. So you can't just have everybody sign these agreements, stick them in their file in case, all right? Up until this decision, we did not have clear law that said that a one-time waiver was enforceable or whether we needed to get them on a more frequent basis. Now, having said that, we were pretty clear it was okay, or we wouldn't have recommended it to all of you who we did recommend it to. But we did not have a really crisp, clean decision on this issue. So the trial court agreed with the employer, but these employees appealed. Good news, the Court of Appeal here in California also agreed with the employer. They said that as long as the meal period is revocable, it can be prospective, and you only have to sign it one time as long as there's no evidence that it is unconscionable, that the waiver is unconscionable, or that it is unduly coercive. Now, the unconscionability and the unduly coercive comes together when we talk about their ability to revoke the waiver. Really important that they have the ability to say, I changed my mind. Without being able to do that, you're going to have a problem on enforceability, because every contract you have with your employee, remember our discussions about arbitration agreements, right? Every document you have that you want to enforce against them or against their interests as they're currently claiming, you're going to face the argument the agreement was not valid, that it was overly coercive or it was unconscionable. So you want to make sure you write these appropriately. When you look at what you can do as an employer, there are 4 things that we think you should focus on that will maximize your ability to enforce these meal period waivers. And by the way, these are not magic, okay? I'm sure there's a bunch of law firms have already talked about this, okay? These are the things that come out of the court's decision. First of all, it should not be a oral or verbal waiver. It should be in writing. The court didn't address that issue. The court didn't also address whether you could just have an agreement in your handbook. But we think, just like with arbitration agreements, don't take the chance here, right? Don't put it in your handbook. You want every individual employee, team member, or associate to get the document, to be able to read it, to understand it, okay? We know that a prospective waiver that is issued at the beginning of employment is enforceable. So do that, all right? Now, you also need to remember, of course, that these waivers are going to be affected by which wage order your employees are covered by. So you do need to understand what wage order applies to you. There is a great resource available on the DLSC's website to help you figure that out. Once you figure that out, then you can look at the wage order and decide if they can waive a meal period. We think it's important to have a waiver both for the first and the potential second meal period. What we call it in our practice is a 6-hour waiver, and then a separate document that is the second meal period waiver. That is very important. In this case, in the Bradbury decision, they only discussed the first meal period, but the logic is very clear, and it would seem to apply just as equally to second meal period waivers. We think you actually probably will get a lot more mileage from the second meal period waiver, because many of your folks are going to work more than 6 hours in a shift. But the beauty of the second meal period is, under most wage orders, if they work more than 10 hours in the shift but fewer than 12 hours total, and they took their first meal period in a compliant manner, they can waive the second one. They don't have to take 2. So that's very important. The third thing that you've got to think about is communicating with your employees when you give them the waiver to sign, all right? We don't want them to be able to testify down the road, I had no idea what this document was. My manager just said, here, sign this, didn't give me a chance to read it. That's not where we want to go, okay? You've got to talk to them. You've got to explain, listen, this is a waiver. If you don't want to take your meal period, either that 6-hour meal period or the second meal period, this is a document that will let you do that. But I want you to read it, and I want you to understand that you have the ability to change your mind at any time. And by the way, don't write something in there that says you have the ability to change your mind as long as you give us 60 days notice. No. If they want to revoke their meal period waiver, they can do it today and waive their meal period today. Okay, so you have to have a process in place that is going to work from that perspective. Obviously, if your employees decide, one or more of them decide they don't want to sign a waiver, you can't retaliate against them. You can't punish them for that. And this is a provision that is in a lot of the labor code substantive areas. So you can't retaliate against somebody who wants to take California Healthy Families, Healthy Workplaces sick leave. You can't retaliate against someone who exercises their 244 rights to take time off as contained in the labor code. You have to be very careful about how you are treating employees after they tell you that they don't want to sign a waiver. Remember, this is completely voluntary. So if they tell you they don't want to sign a waiver, or they sign one and then they revoke their agreement, just let it go. It doesn't matter, right? You just want to make sure you tell the managers and supervisors, look, don't treat this person any differently. They haven't done anything wrong. They've revoked their waiver, or they decided not to sign one in the first place. Totally fine. So training is going to be really important in this area. I've started to think that we need to have a mid-year training on legal updates, because so much happens during the year that by the time you get to the end of the year and you expect people to remember this kind of nitpicky stuff, it's going to be tough sledding. So we think it's important, even if you had even a monthly, for example, Q&A or brown bag with your managers and supervisors where you could bring this up. That would be a fabulous idea. The concept is these employees are waiving something that is waivable. Some things are not waivable. Overtime. So I can't tell you, hey, I'm going to work an extra 2 hours today so that I can leave 4 hours early tomorrow, right? And then let's just keep my time written the same way. No, we can't do that, right? That's not the way it's going to work. When we talk about waiving a right, if that person tries to finagle their time to not work overtime, you might appreciate it. You might think they're nice, but they're violating the law, and you're allowing them to do it, so you're violating the law. So you don't want any shortcuts here, right? You want to make sure that everything is clear in terms of how these meal periods work. Can somebody want to take a meal period one day and not the next day? Sure. James may come to you this morning and say, hey, I don't want to take my meal period today. I want to waive it because I want to leave after my 5 hours and 35 minutes to go to the doctor. Or I don't want to take my second meal period because I want to be able to leave earlier. There are ways to be flexible in this area with meal periods, but you have to be sure that you're communicating and that your employees understand exactly what you're expecting of them. By the way, when I say you cannot put the meal period waiver in your handbook, remember, anything you want to enforce with the employee, a meal period waiver, an arbitration agreement, you're going to have to cut it out of the handbook and put it as a standalone document. So this is an important issue when you talk about meal periods, right? In California, the compliance is very tough. The penalties are very strict. You can have a PAGA claim if you don't do this right. So if you're going to do a meal period waiver, which I think everybody should, quite honestly, that will apply whenever they tell you they want it to apply or they don't tell you they don't want it to apply. After this decision, you can do that one and done. You have it in writing, and if you include everything in the language that the court looked at for how that company's meal period waiver was written, you will be just fine. That will help you get to where you need to go. But we have to be able to show that we had the documentation. So it cannot be something verbal. It cannot be something in a handbook. All right? So when you have non-exempt employees who are supposed to take meal periods, look at your wage orders, make sure you understand when you're supposed to be giving them, and then get them to execute a waiver. It is now perfectly legal, and it is a great practice. It will save you a ton of money if you're willing to do this. Everyone, thanks for joining me today. I had a great time as always. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.